Welcome and thank you so much for tuning into the Greatness School YouTube channel. The channel where diamonds come to meet fellow diamonds to sharpen each other to greatness. Indeed, you are a diamond. I am your brother Ambrose Weda Esq, lawyer, mentor, and author. Kindly listen carefully to this video and others on this channel. If you find them enlightening and sharpening, I request that you subscribe if you have not done so as yet. Click the subscribe button and turn on the notification bell. Newer and more enlightening videos are forthcoming. You should not be left behind. You can also ask a question. Give us your feedback through a comment. You can also recommend to a friend, a fellow diamond. Thank you so much and welcome. Welcome to the Greatness School. The Greatness Talk platform today is on trial advocacy. Top 7 courtroom strategies. Good trial advocacy is resting on persuasion. Your ability to persuade so that the court believes and accepts what you're proposing. And this requires strategy. This requires thinking. This requires a process. You can only persuade a person if you understand that person. You can only persuade a judge if you understand the judge. It is not for the judge to understand you. It is you to understand the judge or the magistrate. But if you do not, you may not persuade. Good persuasion entails taking over the mind of the court and supplanting that mind by replacing it with your own mind so that they accept, he or she accepts what you're proposing. To do so, there are 7 key things you should put into place. There are 7 key strategies you should adapt and adopt and apply. Number 1, the first thing you need to do is to understand the unique characteristics of the individual judge or magistrate or the presiding officer. You ought to know who you are appearing before whom your case is coming or is listed. Get to those things that sets him or her apart from the rest, the unique characteristics. Those unique characteristics are what will influence his or her decision. You look into things like age, gender, life experiences, race, tribe, training, life experiences, intellect, and even prejudices, judicial philosophy, and past decisions. They play a key role in how a person makes a decision. To get this, you need to have known your own personal experiences. You ask around those who have appeared before the judge, those who know the judge, his or her friends, classmates. You must be clear about his or her judicial philosophy, life philosophy, how they view vis-a-vis the case you are going to present. You take all these factors into account when preparing your case. You prepare to meet those expectations in a way that would persuade. You can only connect if you overcome these barriers by using this knowledge you acquire. Don't just appear before any court. You do not know what they think, who they are, how they view life, and then you make a case that may itself be fairly controversial. Tap into the power of the unique characteristics to persuade. That is a critical strategy you must have at all times. Number 2, when you enter the courtroom and the court begins the session and you are about to start your case, you have been given the green light and you are making the introductions, please read the mood of the judge or the magistrate. The prevailing mood that day. take into account his or her emotional standing. This you can read from the body language. You can look at the countenance, the facial expression, the first words he or she speaks in court. You must get the mood clear. You must get it perfect. It will determine how you proceed. Do you adjourn the case? Do you carry on? Do you start with the hard facts or whatever? It determines the mood. Look at the health condition. Somebody may come in and you can see somebody looks unwell. Somebody looks tired. Somebody looks depressed. All this you take into account. What I call the state of the mind and the physical agility. Look at the level of enthusiasm. Are they agile, ready and willing to go on with the work? Enthusiastic or bored and tired and being forced just because they have to work? You have to read this, because depending on this condition, you may decide to proceed or not to proceed. Use what we call emotional intelligence to read this. Remember that even the greatest, the best, the most amiable judges or magistrates have their good days and bad days. They have their moods. Every human being has his or her own moods. Take cue from this assessment and act in consonance. Adapt to it. Make a decision based on this. Reading the mood. Number 3, listen and read the mind of the court. As the trial continues, in the course of the trial, please look at the court carefully. Listen carefully. You listen to the directions, spoken and unspoken messages, subtle messages, body language, eyes. Look at the eyes. Listen to the words carefully being spoken so that you see, you get to tap into the train of thought. Get into his or her mind. Look for clues, sparks, any useful action that may give you a clue as to what the judge is thinking. And this you look at and you look for throughout the trial. There's times when they'll communicate, we are tired. I am tired. There's a time they'll communicate, we want you to continue, move fast. There's a time they'll communicate, stop going in that direction. All this may be direct or indirect. There are times when the court is simply not listening. You have to listen to that to see, find out. There's a time when they are not seriously engaged. They are bored. You get into their mind and you bring them back. And when the court is talking, you freeze. You listen. You understand. You read the mind. And from there you tap in. Plug into the mind of the court. It enables you to control it to where you decide to go. Number 4, enter into the mind of the court. After listening and knowing and discerning and reading, enter now into the mind. How do you enter? Use appropriate tone. A tone that is persuasive, a tone that is likable, and select your words to be applied with the tone or in the tone. From your reading of the moods, select your words carefully and your tone. Polite words, subtle praise, sympathy, and support, together with a declaration of confidence. This would work miracles. Punctuate your mind, your speech with some of this. If you can see the court having a train of thought, acknowledge what the court is thinking. Support it, even when you disagree. And then along the way, find a way to subtly depart and then invite the court to believe and accept your version. That is how we get into the mind of the court. It gives you power to direct it to your desired destination. If you don't capture the thought, if you don't enter the mind, enter the heart, you may just talk as if you are talking to a stone. You may just present evidence which is turning into deaf ears. So capture the mind. Number 5. After you have entered the mind, now attract the court. Attract it. In other words, present your material in such a way that the court cannot resist coming to your side, believing you. You're supposed to work like a magnet. Draw the court, the train of thought. This again is polite, persuasive speech. That is backing logical presentation, clarity of thought, good English language if you're making presentations in English. Clear, short, clear, good sentences. You look what you speak. What do I mean by that? Dress in a way that inspires confidence in your personality. Dress according to your assessment of the court. There is prescribed dress code. Get it properly. Look neat, well done, well minted. It is more easier way to determine proper dress code than guessing. Remain respectful and civil at all times. But above all, look pleasant and confident. That's how you attract the court. They look at you, what you say with a lot of confidence, clarity of thought, logical reasoning, sound knowledge. You become highly believable. Make the court to respect you. This will give you power over the court, and it will come to believe what you're saying. Number 6, assist the court. Assist the judge or the magistrate. You assist by teaching, showing, demonstrating. The court may not know your case, the case you are putting. The court may be interested, may not even be interested in knowing your case. The court may agree or may not agree with you. But when you offer assistance by teaching, by demonstrating, by showing, there is a human tendency to reciprocate a favor, to pay you back for a good turn, just like they'll pay you back for a bad turn. So when you give enlightening teaching material and the court gets to understand what you are saying, there's always a tendency to pay you back by what you have done, the good you have done. So therefore, teach the court to understand your case. Answer questions clearly and properly and honestly. Address all the concerns that the court may raise. Settle all doubts that may arise over the case you are putting forward. Remember, good teaching makes you look very brilliant, very able, and makes your case look truthful and acceptable. So assist the court at all stages, at all levels. Number 7. Excel beyond expectation. There's a level the court expects you to deliver your case. Exceed that level. Do beyond expected. Be clear, be good beyond expectation. Deliver more than envisaged. Clarify things deeper and higher. Display deep knowledge, clear understanding of the issues before the court, the law, the procedures, facts, and even relevant guiding policies. As you guide, be polite, distinguished, and respectful. Again, this works well when you are fairly well dressed and you look nice. You look what you are saying and you speak well. As you do this, you keep to the point and you remain orderly. Of all your display good knowledge, sound understanding, ability, and fluency. As you do this, keep the time. Work within the time allocated. Do not go too far, do not be too short. If you are too short, it looks like you do not understand your case, or your case is not good enough. If you are too long, it becomes boring and difficult, and even the sound, serious facts and issues you have presented may be forgotten. So keep time. In conclusion, allow me to quote an ancient Chinese military strategist and the author of a famous book called The Art of War. They call him Sun Tzu. He said, and I quote, "Strategy without tactics is the slowest route to victory. Tactics without strategy is the noise before defeat." End of quote. Combine tactics and strategy for a clear, well-put victory in court. Thank you so much, and God bless you.